Good morning. I hope you're all enjoying the Academy this year, and this is always a very special part of the Academy each year, the Distinguished Lecture. And this year I'm really delighted to briefly present Christine Chinkin, because I think it's always interesting to hear a little bit about the biography of the Distinguished Lecturer, because it's also a kind of inspiration for the kinds of things one can achieve in life if you're very lucky and talented as well. So Christine is currently a Professorial Research Fellow and founding director of the Centre for Women, Peace and Security at LSE. She is also, because that would not take up enough of her time, a William W. Cook Global Law Professor at Michigan University, a member of the Bar of England and Wales and Matrix Chambers, and before that she was for many years Professor of International Law at the LSE as well. So why are we particularly pleased that Christine accepted our invitation to deliver this year's Distinguished Lecture? She's really a pioneer, I would say, in the field of international human rights law, in her work as both an academic and an activist, with both of these strands of her work really feeding the other. And that work has been not only, but very importantly, directed towards recognition and furtherance of women's human rights. So she's advised numerous international organizations, including in relation to trafficking against women and violence against women, and perhaps most notably, recently served as one of the key legal advisors in the drafting of the Council of Europe's Istanbul Convention on preventing and combating violence against women, which was just telling me now she discovered just through some chance interactions last week has been having lots of powerful effects on the ground, so that's very heartening. Christine really contributed, I would say, with her collaborators to the emergence of a new field of international law. And this is especially encapsulated in her groundbreaking book with Hilary Charlesworth in 2000 on the boundaries of international law, a feminist analysis, which examined the status of women in human rights and international law and provoked a very productive controversy and within the larger community of international lawyers. Now, alongside this central and really path-breaking set of contributions to gender and international law, she has also contributed in many other ways to the scholarship and practice of the field. So just to give a few little examples, she co-authored with Alan Boyle in 2007, The Making of International Law, and with Mary Kaldor in 2017, a book on international law and new wars. She has been a member of the Human Rights Advisory Panel in Kosovo for 6 years, a member of a challenging UN fact-finding mission on the Gaza conflict of 2008 and 2009, and has also participated in various ways in litigation before the International Court of Justice, the European Court of Human Rights, and the Inter-American Court of Human Rights. Now, unsurprisingly, given this roll call of really awe-inspiring achievements, she has received already many accolades. So she's a Fellow of the British Academy, a companion, I think this is my favourite, a companion of the most distinguished Order of St. Michael and St. George, which is an honour awarded by Queen Elizabeth II for service in connection with foreign or Commonwealth affairs. She was awarded the American Society of International Law Butcher Medal for outstanding contributions to the development or effective realization of international human rights law in 2005. And last but not least, on the 14th of June 2019, just a few days ago, she was awarded a Doctor Honoris Causa of the European University Institute. Now, I assumed that Christine would stay on in Florence and, hang out by the swimming pool between last week's graduation ceremony and today's distinguished lecture, but she flew back to London because, as she said, one of my postdocs is organizing a workshop and I cannot miss it. So I think this tells us just what a generous and committed senior scholar she is, and it also allows me to say how especially grateful we are for flying back, doing a return trip to Florence in 2 days or 3 days to deliver today's distinguished lecture of 2019 on human rights and the woman, peace and security agenda. So thank you so much, Christine.
Well, it was pouring with rain in London, so, you know, there were good reasons for coming back again. Thank you very much, Claire, for that very generous, highly embarrassing introduction. Thank you, Grania, for the invitation to come here in the first place. And thank you all for coming to the lecture. Okay, so I think the subject of the lecture, human rights and women, peace and security, is a subject that figures, women, peace and security, is a subject that features very widely in the international relations literature, in the political science literature, but almost no reference at all in the international legal literature or in human rights literature. So it's an unusual lecture to be giving, I think, in a course on human rights. A big handbook on women, peace and security, something like, you know, sort of 60 chapters or something has just come out recently. And I think, I mean, there is almost no chapters by international lawyers within it. I was going to say, I think there's only 1 or 2, but perhaps a couple more, but very, very few. And I think it's also unusual because it centers on the Security Council, which of course is the New York bit of the UN, as opposed to the Geneva bit of the UN, which deals with human rights, and the sort of compartmentalization, the siloing that we get in the, within the United Nations also then raises the issues around institutional division and how the substantive relationship between the various parts of the UN, peace and security, human rights, actually operate together. So what I want to do in this lecture is, first of all, to examine the origins of women, peace and security, say why I think it is appropriate to be talking about it in a human rights course, the content of the various resolutions of the Security Council from the perspective of human rights, and to very much compare this with the work of the Committee on the Elimination of All Forms of Discrimination Against Women, the CEDAW committee, that has also dealt with some of the same issues, and then to consider where women, peace and security is today in terms of human rights. So that's the basic framework. So the first question is, well, what do I mean by women, peace and security anyway, and why do I think it's appropriate to present this as a topic in a lecture on human rights? And for those that heard some of the lecture last week, I hope there's enough difference so that it's not just a repetition of the same. Right, the origins of the Women, Peace and Security agenda are usually said to lie in the adoption by the Security Council in the year 2000, Resolution 1325 on women and peace and security. In this resolution, the Security Council identified that, to quote, an understanding of the impact of armed conflict on women and girls, effective institutional arrangements to guarantee their protection, and full participation in peace processes can significantly contribute to the maintenance and promotion of international peace and security. So the resolution, thus, on its face, links women's experiences of conflict with the Council's primary responsibility under the United Nations Charter for the maintenance of international peace and security. So it brings women's experiences of conflict into the agenda for peace and security. Now, Resolution 1325 has been followed by 8 other Security Council resolutions. The most recent was adopted on April the 23rd of this year. So taken together, they accumulate a body of normative standards and measures that are urged upon states, UN institutions, and civil society. And so I think it's become appropriately called an agenda. These are 8, 9 now, resolutions together. But is it a human rights agenda? In 2015, the Security Council commissioned a global study on the implementation of Resolution 1325. And one of the conclusions of the global study was that, to quote, 1325 had been conceived of and lobbied for as a human rights resolution that would promote the rights of women in conflict situations. So what the global study is saying is, in its origins, it was a human rights resolution. So let's go back and look very briefly at the origins of the resolution in the 1990s. Now, the 1990s, of course, were this decade of, looking back now, of great optimism following the fall of the Berlin Wall, the fall of the Soviet Union, when there was a great deal of talk about a new international order and an oft-repeated mantra of democracy, rule of law, human rights. Everything at that point was seen, in that sort of mantra-type framework. Right, now the 90s was also a time of great organisation, lobbying and campaigning by women's non-governmental organisations. They were building particularly on what had been the UN decade for women between 1975 and 1985. But the women's organisation around these issues goes back at least until the very turn of the 19th, 20th centuries, when women were campaigning around issues of peace and disarmament, political rights for women, and the rights of working women. And I think especially significant is that in 1915, there was a Women's International Peace Congress that was held in The Hague while World War I was raging. And essentially, it was a peace congress in which women from primarily Europe and the United States came together seeking to stop the war and to give their account of what should be in a peace agreement. And many of the resolutions that were adopted back in 1915 and then again in 1919 have their echo in the Security Council in some ways, in the Security Council resolutions in the 2000 onwards. So coming now, we have the decade 1975, 1985. In the 1990s, this sort of period of openness and enthusiasm for human rights, women's organisations now deliberately target UN Global Summit meetings. And so, for instance, at the 1993 World Conference on Human Rights in Vienna, women's non-governmental organisations gained some great advances with respect to the human rights of women. So, for example, they get the statement in the Vienna Declaration. Now, this is 1993. It sounds probably pretty dated now, but at the time, this was really quite revolutionary stuff. They got the assertion that the human rights of women and the girl child are an inalienable, integral, and indivisible part of universal human rights, that states should work towards the elimination of violence against women in public and private life. And 1993, the war in Bosnia is raging just down the road from Vienna. So there was, again, particular emphasis on violence against women in armed conflict. And so they also secured the statement that violations of the human rights of women in situations of armed conflict are violations of the fundamental principles of international human rights law and humanitarian law, requiring a particularly effective response. Now, this challenges straight away the traditional binary between international humanitarian law applicable in armed conflict, human rights law applicable in peacetime every day. They're saying this applies to both situations, and I think carries with it the germ of an understanding that subsequently gets developed of a continuum of gender-based violence against women from everyday peacetime through into the situation of conflict, and that essentially what conflict does is exacerbate what happens to women in non-conflict situations, rather than constituting something entirely different. There was a great deal more in Vienna, but another important point is that it was also added that, quote, the equal status of women and the human rights of women should be integrated into the mainstream of UN system-wide activity. So the concept of what we now call mainstreaming was flagged back at Vienna. Okay, then we get 2 years later, the Fourth World Conference of Women in 1995, Beijing Declaration and Platform for Action. Beijing had 12 critical areas of concern. One critical area of concern was the human rights of women, which echoes and develops further what had been said at Vienna. But then at the instigation of a number of women's organizations focused particularly on peace, there's a critical area of concern which is targeted specifically at women in armed conflict. And the critical area of concern on women and armed conflict includes the call for governments to, quote, increase the participation of women in conflict resolution at decision-making levels and to protect women living in situations of armed conflict or under foreign occupation. Participation, protection. So we start getting these key principles being set out in these sort of global policy blueprints, essentially, the statements of the global summit meetings. But then there was a great feeling of dismay, I think, and disillusionment among these women's organizations when literally 2 months, Beijing was in September, the Dayton Peace Agreement, which brought an end to the war in Bosnia, was in November of that year. Despite the assertions at Beijing, not one single woman was included in the negotiations at Dayton, a pattern that we see constantly throughout peace agreements. And then I think there was actually one woman in the UK delegation. There was nobody from Bosnia, nobody from any of the other areas of the former Yugoslavia, and the woman from the UK delegation apparently contributed very little. She was there as a member of the FCO, basically. So anyway, women's organizations, women's NGOs at that time, then decided essentially that they would shift their attention and try and engage a more politically powerful arena than the global summit meetings. Now, women's NGOs on their own can do a great deal. They can certainly create pressure, etc. But what they need is states to carry forward their agenda. They can't do it on their own. And through lobbying and so on, they brought on board, in particular, Namibia and Bangladesh, who were the two champions at the time within the Security Council. Now, UK diplomats keep telling me that the UK was vitally important at this point. None of the women's NGOs archives reflect this, so I'm not quite sure, who is trying to claim credit there or not. But the UK are very insistent that they were very important as well. Institutionally, women's organizations work closely with UNIFEM, which is the Women's Development Organization, now part of UN Women. And they also made use of what is known as the ARIA formula within the Security Council. Now, the ARIA formula, let's backtrack a moment. The Security Council is essentially impermeable to civil society, non-state actor participation. The ARIA formula, which was introduced around this time, and I'm not sure if this was literally its first use or not, but essentially brings members of the Security Council outside the formal sessions, so outside the debates and where they actually adopt the resolutions, to informal meetings outside, but which enable civil society organizations to lobby, exchange views, provide information, etc. To the Security Council. So with the assistance of the states, like-minded states that I've just mentioned, and through using the ARIA formula, they achieved 1325 in 2000. Women's activists widely celebrated this. It was the first time that the Security Council had ever devoted an entire session and an entire resolution to women's lived experiences of conflict, and link them to the primary responsibility for the maintenance of international peace and security. So, what does 1325 actually say? And here you can hear echoes of Beijing in particular, in that it has two main themes: gender balance, which is about increasing the number of women in participating in all levels of decision-making relating to peace processes, national, regional, international, also including more women in positions of institutional significance within the United Nations, special envoys, members of commissions of inquiry, special representatives of the Secretary General, etc. I think, and this is something we might want to talk about, it's noticeable that while the importance of the inclusion, participation by and representation of women is emphasized, no reason for this is given. There's somehow an assumption that if we include women in these processes, they will somehow definitely be better and lead to better peace. Why? Are women good at peace? Who knows? And this might be something that we might want to think about. Gender mainstreaming, the gender perspective into all areas, was promoted through urging all actors involved to take a gender perspective in post-conflict policy making to support local women's peace initiatives and indigenous processes for conflict resolution, and to ensure the protection of and respect for the human rights of women and girls, particularly as they relate to the Constitution, the electoral system, police, and the judiciary, the core of post-conflict peace building. And 1325 also emphasises the importance of putting an end to impunity, prosecution of those responsible for genocide, crimes against humanity, and war crimes, including sexual and other forms of violence against women and girls, and the importance of exclusion of such crimes from amnesties that are often included in peace processes. Okay, so is 1325 a human rights resolution? Now, there's certainly some language relating to human rights. So in the operative paragraphs, all parties to armed conflict are called upon to respect fully international law applicable to the rights and protection of women and girls, including international humanitarian law, the 49 Geneva Conventions and the 1977 additional protocols, the Refugee Convention, and the Human Rights Treaties. And in particular, CEDAW, the UN's blueprint for women's human rights, is included in those operative paragraphs, as is the optional protocol to CEDAW. And then following Beijing, this first Women, Peace and Security resolution makes participation and representation really the primary focus. The first 6 paragraphs of Resolution 1325 are all about participation. Now, of course, this is already part of international human rights law. Article 7 and Article 8 of CEDAW emphasize the state's obligations with respect to women's participation in national political decision-making, Article 7, and in international law decision-making and participation in international institutions in Article 8. So it's already it's already there in human rights law. But what is interesting, and I think this is a theme that gets developed as we go through, 1325 doesn't talk about women's right to participation, but rather talks about it in instrumental terms, stating essentially that women's full participation can significantly contribute to the maintenance and promotion of international peace and security. So it ties women's participation to this a security angle rather than to a right to participation. And another sort of theme that I think runs all the way through the WPS resolutions, participation is never explained. What does participation mean? Turning up, being allowed to speak, being listened to, being included in agenda setting, all sorts of issues about what does participation actually mean. So I think it is fair to say that, yes, human rights were important in the adoption of 1325. It was part of the vocabulary of the day. Many of the women's organisations involved were clearly focused on women's human rights. But we also have this other agenda running through, dating back at least to 1915, which is essentially advocating for a feminist peace agenda. And some of the women's organisations were far more focused on the peace angle rather than the human rights angle. Leads to another question, I think, are those two compatible agendas? How do human rights and peace fit together? And is there even a sort of let-out being given to the Security Council from the word go by having different agendas from different women's groups and allowing the Security Council to sort of backtrack from both in some ways? Because I would say that the history since 1325, in some ways at least, is a backtrack from those early agendas. So that's year 2000. Of course, and overshadowing everything, we get 9/11 in 2001, which I'll come back to. The next WPS resolution is in 2008. And here, the sort of primary focus of the resolution shifts from women's participation, which is essentially about agency, to protection of women and protection of women and girls against sexual violence and armed conflict. And again, this is linked to the security angle. so that the resolution stresses that sexual violence, when used as a tactic of war, exacerbates armed conflict, may impede the restoration of international peace and security, and that steps taken to prevent such violence contribute to the maintenance of international peace and security. And therefore, the Security Council demanded the cessation of all forms of sexual violence during armed conflict and offered various suggestions as to how women should be protected against such violence. 1820 is, in some ways, I think, a very good resolution. It emphasizes that sexual violence as a tactic of war is an impediment to international peace and security. One might have thought it might emphasize as an impediment to women's bodily integrity and enjoyment of their rights, but they put it in the security framework. But it does mean that the Council rejected the characterization of sexual violence and armed conflict as an inevitable byproduct of all forms of war. It recognized it for what it is. It's a war crime, it's a crime against humanity, it can be used genocidally, as, for example, we've seen recently in the case of the Yazidis. It's a crime of humiliation, it's an assertion of power and control, and, of course, a violation of human rights of women, as had been spelled out in Vienna some 15 years earlier. But what the Security Council doesn't do in addressing sexual violence in armed conflict is to look at the many other reasons for conflict-related sexual violence. It's not just a tactic of war. It's used for multiple other reasons. It's committed by the state and state agents, as well as those acting against the state, such as armed groups and militia. It's also used in various manifestations by those who are not involved in the military action. So, for example, under a general rubric of conflict-related sexual violence, we can see the actions of families who are desperate to save their daughters from random rape that may occur and therefore engage in forced marriage. They think that by forcing their daughters into marriage with someone else, they will make them safe. They may also engage in forced marriage for money. Because they are simply desperate for food, resources for the rest of the family. Conflict-related sexual violence is extremely complex, multiple perpetrators, multiple reasons for it, and bringing it all into a tactic of war framework discounts those many complexities. Nor does it recognize the many other forms of harm that are gendered and that occur to women and girls during armed conflict. Many examples: the denial or unavailability of appropriate health care following sexual violence, access to antiretroviral drugs, for example, access to abortion, the destruction of property and food sources, which are especially significant for women who are the primary caregivers for members of the family, the altered demographics, creating more women-headed households and the threats that face women-headed households, the impact of missing male relatives and accessing property, accessing land, and the absence of male relatives and absence very often of documentation. Resolution 1325 and 1820 do recognise one particular area of increased risk in conflict-affected sexual violence, and that is the situation, the particular needs of women and girls in refugee and IDP camps. So in 1820 requests UN agencies to develop effective mechanisms for providing protection from violence, in particular sexual violence, for women and girls in and around UN-managed refugee and IDP camps. In particular, now, one thinks of flight and displacement. These are particular areas of creating further vulnerabilities for women and girls, including particular issues of transactional sex, exploitation, sexual exploitation, and trafficking. And I think it's in line with the general approach of these resolutions that the call is for protective measures, not on the rights of refugee women and internally displaced women. And also, they do not call upon states to ensure an environment that would reduce such vulnerability. So it's this protective language rather than the right language and state obligation language that gets emphasized. The Special Rapporteur on Trafficking has put it this way: increasingly restrictive migration policies, insufficient channels for regular migration and family reunification, lack of regular access to the labour market for asylum seekers all further contribute to an increase in the exploitation of migrants, including through trafficking. These are areas of state policy, making, to my eyes at least, the state complicit in the violence that then ensues. So there's no analysis around that sort of area, rather than just saying they should be protected when they're in refugee camps. So the emphasis on sexual violence as a tactic of war is limited and limiting. It has the potential to create a hierarchy of victims, which is contrary to the universalism of human rights. And rather than emphasizing women's agency, it portrays women as victims requiring protection. Now, a depiction of women as passive victims requiring protection necessarily carries with it constructions of men, and this is implicit throughout the WPS resolutions. Men are implicitly both those who cause the violations and those who are asked to go and protect women against the violations. And while there is no specific reference in the resolutions to the Global South, the assumption is very much that it is the women in the Global South who need protecting by the men from elsewhere. And this has led rise, I think, to one of the critiques of women, peace and security, that it's become very much about northern aspects of decision-making with respect to women in the South, including being used as a justification for military intervention in some situations, which, that imperialist post-colonial critique is played into it. As I said, there's no specific reference in the resolutions, but there is a reference to the Council adopting measures to address widespread or sexual violence when considering situations on its agenda. And the Security Council's agenda is dominated by the situations in the South, so it tends to work through that way. That men and boys, let alone people of other gendered identities, should also be protected against sexual violence is not considered in at least these earlier resolutions. Although the Security Council uses the word gender, it essentially is talking about women. So, as with participation, in Resolution 1325 and 1825, the emphasis is on security rather than on rights, and so we get this instrumentalization aspect. Now, this may have been inevitable. By locating these issues within the Security Council, it may be that it was inevitable that the Security Council's understanding of security in a militarized, masculinized type way was always going to prevail. And essentially what we have is a securitization of rights, transforming people into objects of the security apparatus rather than as rights bearers would be the consequence. As has been commented, maybe this was a high price to pay that wasn't appreciated back in 2000. Okay, the ensuing 6 resolutions fluctuate in various ways. Some put participation to the fore, others are centrally focused on protection against and prevention of sexual violence. And by 2015, when we've had 8 of the resolutions, the WPS agenda is regularly described as comprising 4 so-called pillars: participation, protection, prevention of sexual violence, and also of conflict, although this tends to get just mentioned but never developed in any way, and post-conflict relief and recovery. In its later resolutions, the Council does encourage what it calls women's empowerment, although again this is linked to other objectives. So for instance, a resolution adopted in 2013, women's empowerment is said to be, quote, critical to efforts to maintain international peace and security. You should be getting the message by now. And to contribute to the stabilization of societies emerging from armed conflict. Nor, again, is there any explanation. What does empowerment mean? Is this political empowerment, social empowerment, empowerment in face of various cultural type obstacles? And further, I think empowerment should be seen as a strategy rather than as a goal. The goal should be gender equality, but that too tends to get rather lost throughout these resolutions. So I think after these first two resolutions, 8 years apart, but which very much set the framework for the agenda, what we have is some dilution of both the rights language and the peace language. And so I want to just look at how this dilution plays out and then look to see what the latest resolution, the one that was adopted in April of this year, adds to this. So the first and foremost way in which the commitment to human rights is diluted is the shifting language with respect particularly to CEDAW. 1325, as I said, CEDAW is incorporated in the operative paragraph of the resolution. In later resolutions, sometimes it is referred to in the preamble. Now, people argue about what is the relevance of a preamble to a Security Council resolution. The general view, I think, is that this is where you park things that you don't think are really very important. And so I think putting it into the preamble rather than putting it into the operative paragraphs is clearly a downgrading of the issue. Some of the resolutions, they don't even mention CEDAW at all. So there is a disappearance, I think, of CEDAW. Secondly, the later resolutions start talking more about measures for relief and recovery. This is the immediate emergency care and more long-term societal reconstruction. But they're put forward in the language of humanitarianism, not in the language of rights. So to take one example, a resolution in 2013 recognised the importance of providing timely assistance to survivors of sexual violence, urging provision of non-discriminatory and comprehensive health services, sexual and reproductive health services, psychosocial, legal and livelihood support, taking into account the specific needs of persons with disabilities. Well, all of this can be recast in the language of rights. What is being called for, healthcare, other multisectoral services relating to sanitation, shelter, food, livelihood, etc., all clearly come within the Covenant on Economic and Social Cultural Rights. They come within CEDAW itself. In Africa, where many of these conflicts are taking place, they come within the African Charter of People and Human Rights. So they could be cast in that way in rights rather than as in services. And I might note that all three of those conventions do not provide for derogation in times of conflict, so therefore are applicable also during armed conflict. But I'd argue it's not just a matter of humanitarianism, it's also a matter of access to justice and prevention of further human rights violations. All the Women, Peace and Security resolutions emphasise ending impunity for crimes of sexual violence, asserting accountability, transitional justice. I would argue that ensuring that access to and delivery of economic social rights in the post-conflict moment are absolutely essential to this objective. That securing women's living standards, ensuring that they have got the stability and health care that is necessary, will make them more able to participate in transitional justice programs. If you're wondering desperately where you're going to get your next food, how are you going to look after your children, what are we going to do about the injuries sustained during conflict, transitional justice, important though it is less likely to be at the top of your list of priorities. And so economic and social rights, which get downgraded generally, are here recast as services and humanitarianism. Now, I suspect this may well have something to do with the fact that the United States of America is not a party to CEDAW, it's not a party to the Covenant on Economic and Social Cultural Rights, It's not a party, actually, to the Inter-American Convention either, which also includes economic and social rights, but is, of course, a key player in the Security Council, and is particularly, sees itself as a champion of women, peace and security. So I think it's not so surprising that we get this sort of shift in language and approach. Right, so that's two ways in which human rights have been downgraded. Third is the shift in the geopolitical environment since 2000, obviously following 9/11, the fight against terrorism, and more recently the fight against violent extremism, becoming a predominant, if not the predominant, concern within the Security Council. In the 2015 resolution, a linkage was made between women, peace and security and counter-terrorism and counter-extremism policy frameworks. The resolution acknowledges that extremism and terrorism in all its forms have serious gendered impacts on the rights of women and girls. It's manifested through different forms of gender-based violence, forced and child marriage, new forms of sexual slavery, restrictions on and targeting of girls' educational establishments, abduction of girls from schools, harassment against women and girls in public spaces, all refusing, denying access to healthcare, education, livelihood, etc. So Resolution in 2242 in 2015 recognises sexual violence in this situation as a tactic of terror as well as a tactic of war. And so it calls for the greater integration of WPS with the agendas for counter-terrorism and countering violent extremism, and requests the counter-terrorism organisations of the Security Council to integrate gender as a cross-cutting issue across their agendas. The Special Rapporteur on Counter-Terrorism and Human Rights, the most recent one, has looked at the great body of normative standards that are now emerging internationally and regionally relating to countering violent extremism, countering terrorism. And she's raised the general concern that this whole new area of normative standards risks submerging, marginalising, drowning, is the word she uses, human rights. And I'd say that this has the same issue with women, peace and security, especially when they're deliberately brought together in the same resolution. And further, security responses to counter-terrorism have the potential to compromise the role of women's organisations and women leaders within their own communities. The former Special Rapporteur on countering violent terrorism and violent extremism and human rights highlighted the ways in which those subject to gender-based violence are often caught between being targeted by terrorist groups and by the counter-terrorism measures. They're caught in the middle between the two. And very frequently, this may involve perpetration of further human rights violations. These violations are amplified through war rhetoric and increased militarization in countering terrorism. Now, the current Special Rapporteur has looked at an agenda policy of the Secretary-General, and the Secretary-General has expressed his intention to include women in counter-terrorism activities, to build women's civil society capacity to act as a barrier to violent extremism, and to set aside funds to empower women as placeholders for broader economic, social and political reforms on marginal communities that are deemed to be those at risk of producing terrorists. The Special Rapporteur says, okay, this is good. You know, women are going to be brought into these agendas. I would say that there is also major dangers of further instrumentalization, further co-option of women into those agendas. And I must admit, I heard a talk by a member of the US military who was talking about, oh yeah, we're talking to women in Afghan communities and getting them to come and say what's going on within their societies. Which made me think, is anybody thinking about the security of those women and how they are being co-opted into those agendas? Also, I would just add onto this that it adds a risk of further securitization of the Women, Peace and Security agenda, I've already said that, but a further backlash against women's human rights defenders. And what we are clearly seeing at the moment is the targeting of women human rights defenders on a very significant scale. And often people who are then targeted in this way can be called, they were the terrorists. That's why they were targeted, rather than as women's human rights defenders. And especially where women's human rights defenders are perceived as deviating from cultural gender norms, defending abortion, for example, then this can again get caught into that terrorist language. Okay, better speed up a bit. 1325 itself said that effective institutional responses was one of the important ways of addressing these issues. And it has spawned a huge industry of institutional responses at the UN level. So we now have women protection advisors, we have gender advisors, we have gender teams of experts that are deployed to conflict-affected areas to assist national governments in addressing these various issues. We have the creation of a special rapporteur on sexual violence and armed conflict, who provides particular information on the situation in conflict-affected areas, delivers an annual report to the Security Council, keeps the issue on the agenda. But these are, I would say, technical and sort of bureaucratic type responses. And what the Security Council hasn't done is draw upon the expertise of the human rights bodies back in Geneva. The Special Rapporteur on Violence Against Women addressed the issue of women in armed conflict as long ago as 1998. CEDAW has been addressing the issue over the many years. There is a body of experience and wealth of jurisprudence around all of these issues that the Security Council hasn't addressed at all. And that leads me on to the role of the CEDAW Committee more generally. In 2013, and I think not by accident, the CEDAW Committee produced a general recommendation on women in conflict and post-conflict situations on the same day as another Women, Peace and Security resolution. So you get these two documents coming out at the same time. The CEDAW Committee's general recommendation covers a great deal of the same ground as the Women, Peace and Security resolutions, but in very different language and with very different reading through a more nuanced understanding of the key words, women, violence, peace. And so from the human rights perspective of the CEDAW Convention, we get the CEDAW Committee looking at these issues. So women. As I've already said, the Security Council sees women primarily as victims of sexual violence, passive bystanders occasionally brought into peace processes, or people to be co-opted into the terrorism, countering violent extremism agendas. The CEDAW Committee, however, recognises the diversity of women and whose experiences of conflict differ, pointing out that women may be combatants, they may be part of organised civil society, they may be human rights defenders, members of resistance movements, active agents in formal and informal recovery processes. They draw on their early recommendations and also say that women's experiences of conflict differ according to issues such as their ethnicity, their nationality, their refugee status, their sexuality, their gender identity, their health, etc., the whole range of identity characteristics. And so, says the CEDAW Committee, responses should be tailored to these realities and not to some template of an essential woman, which is being cast by the international community. Further, such differences should also be relevant when women are being chosen for the participatory roles, again trying to seek for the widest possible diversity of experience. So that's women. Conflict. The Security Council never defines conflict. And of course, its major mandate is threats to peace and security. But it does assume there is this thing called post-conflict. And presumably, post-conflict is a different situation from conflict. The CEDAW Committee, however, says no. There is no clear distinction between conflict and non-conflict. There's no linear progression between the two. Situations of armed conflict can escalate, they can then fall back down. This may go on over many years. It may be different in different parts of the country. And gender-based and sexual violence also occur in multiple situations that are not peaceful, but do not fall either within the international humanitarian law understanding of international armed conflict or non-international armed conflict, nor into the limited situations considered by the Security Council. So the committee talks of internal disturbances, low-intensity civil strife, political strife, ethnic and communal violence, states of emergency, mass uprising, organised crime. And in all of these situations, the CEDAW committee points out that research shows that violence, gender-based violence, does not stop. It doesn't stop with a ceasefire, it doesn't stop with a peace agreement, and it often increases in these various other situations and in the post-conflict situation. The forms and manifestations may change, but the continuum of sexual and gender-based violence continues, that's bad, and even escalates in that post-conflict situation. Peace. The committee doesn't actually address peace as such, but what it does address in a great deal more detail than the Security Council is conflict prevention. It includes in conflict prevention such classic things as early warning systems, preventive diplomacy, mediation type notions, but it also includes robust regulation of the arms trade, attention to the circulation of illicit arms that come from the regular arms trade. It also addresses root causes. None of these appear in the Security Council resolutions. And it sees entrenched sex and gender-based discrimination that pre-exists conflict and impedes women's enjoyment of the full range of rights and are the causes of violence to women in everyday life are linked directly to the violence that is exacerbated by conflict, the continuum of violence. It also finds a correlation between the increased prevalence of gender-based violence and discrimination and the outbreak of conflict. These are early warning signs for prevention strategies. It also links state discriminatory policies with respect to migration, access to land, justice, and nationality to the objectives of the recommendation, which is protecting women's human rights at all times, advancing substantive gender equality before, during, and after conflict, a very much broader human rights and peace-oriented agenda than the Women, Peace and Security agenda of the Security Council. And importantly, the committee spells out states' positive obligations under general international human rights law. States, as you all know, are responsible for wrongful international acts, including violations of human rights committed by state agents or when the state is complicit. Further, and in line with earlier general recommendations, states are required to exercise due diligence to prevent, punish, investigate, prosecute, and ensure redress for the acts of private individuals or entities that infringe the CEDAW Convention. So it spells out the state obligations under human rights law with respect to all of these issues that are included within the Women, Peace and Security resolutions, but without that emphasis on state obligation. I think this human rights focus that we get from the CEDAW committee is important. Human rights tool provides the tools to challenge the power structures and to recognize the impact of intersecting and interlocking discrimination, providing for state responsibility. The Women, Peace and Security resolutions tend to focus on individual criminal responsibility that does not implicate the state in that same way. And one might also add that the emphasis in the Security Council resolutions on criminal prosecution has essentially not succeeded. We can talk about that for all sorts of reasons, but just as one marker, 17 years of the International Criminal Court, there still has not been one single standing conviction for acts of sexual violence. So the CEDAW committee emphasizes that women, peace and security must be implemented in accordance with the substantive provisions of the CEDAW Convention. And this includes reporting on it, being questioned by it, and the committee responding in its concluding observations. So in contrast, the Council, the Security Council, has never expounded on any of this, nor considered the pernicious effects of the legal arms trade, militarism, militarization, the global neoliberal economic order, and how all of these sustain inequalities and hence violence. The emphasis in the Women, Peace and Security resolutions on women in the security sector, on conflict-related sexual violence as a weapon of war and a weapon of terror, and the almost complete silence about root causes, in particular the political economy of violence and its role in preventing participation, runs counter to the understanding by the CEDAW Committee in its general recommendation on women in conflict and its later recommendation on violence against women, all of which emphasize and reinforce human rights law. Right, I really am overgoing, but just a few words about the latest Women, Peace and Security resolution, very fast. It was adopted, as I said earlier, in April this year. It's been highly criticised by the women's civil society, women's organisations. It's seen as going backwards. It's seen as retreating further from a strong statement of women's human rights in conflict. Its negotiation was contentious. Russia and China both abstained. The United States threatened to use its veto if there was strong language on women's sexual and reproductive rights. What, of course, they meant by that was abortion. If it included abortion. There was also strong objection to the use of the word gender, fearing that this would incorporate the rights of LGBTQI persons. And I think this is an expression that we're seeing within the Security Council of the backlash, the gender ideology, which is now prevalent in many countries across Latin America, into Europe, and elsewhere. However, and while there's a great deal to regret in this resolution, I also think that it actually allows for greater inclusion of human rights than some of the earlier resolutions, and very careful interpretation of 2467, the latest resolution, with earlier resolutions, allows for an assertion of state legal obligations and corresponding individual rights. So, for example, it's the first resolution since 1325 itself to directly incorporate CEDAW into the operative paragraphs of the resolution. So it says that states must recognize the equal rights of all individuals affected by sexual violence and armed conflict, including women, girls and children born of sexual violence and armed conflict. That's a first. Never before have children born of armed conflict been mentioned. Consistent with their obligations under the CEDAW Convention and the Convention on the Rights of the Child. And also this direct language of rights is for the first time inclusive. It's all victims, and so therefore can also encompass men and boys, which is actually made explicit in a later paragraph, and also those who are targeted on the basis of their sexual or gender identity. Coupled with the preambular reference to the CEDAW Committee's General Recommendation number 30, it seems that the Security Council may almost be inviting states to read Women, Peace and Security in conjunction with CEDAW, and the committee to include Women, Peace and Security in its concluding observations, which of course it is already doing, but this may be the Security Council actually acknowledging that. Further, 2467 explicitly refers and unequivocally to, quote, the applicable provisions of international law on the right to an effective remedy for violations of human rights, which recognizes both that these incur violations of human rights and the international human rights obligation with respect to a remedy, which is not linked either to a successful conviction of a perpetrator, that's the ICC situation. Reparations follow if there's a conviction. If there is no conviction, there are no reparations, so there's been no reparations for any case of sexual violence, nor to any requirement that the person cooperates with the authorities. In many situations relating to trafficking, the rights of trafficked persons are linked to cooperating with the national authorities. This just says the right to a remedy. and then link that with the CEDAW committee's understanding of what constitutes an appropriate remedy for women and girls as laid out in its general recommendation on access to justice, I think we have an extremely strong reassertion here by the Security Council of those basic human rights principles. And further, it can be argued that although the rights to sexual and reproductive health are not spelled out explicitly, the resolution does recognise, quote, the needs for survivors of sexual violence to receive non-discriminatory access to services such as medical, psychosocial care to the fullest extent practicable, and to be free from torture and cruel, inhuman or degrading treatment. And that violations of the obligations can amount to serious violations of international law. Well, violations of the right to be free from torture, cruel, inhuman, degrading treatment is a direct lift, from the Torture Convention, and multiple human rights bodies, CEDAW, the European Court of Human Rights Committee, and others, have recognized that denial or criminalization of abortion can come within the prohibition of torture. Therefore, through an interpretive mechanism, one can argue that, it is actually there, although they didn't realize this. I won't go any further. I've talked for far too long anyway. But I think that 2467 is a long and detailed resolution. But in light of the way the negotiations went, some of the language that is there is very surprising, and its linkage back to human rights and CEDAW is in fact something to be welcomed. Now, it may be that they were so anxious in their negotiations to exclude sexual and reproductive rights that they never thought about these consequences of interpretation. Or more cynically, it may be that the human rights implications were just regarded as not very important. Human rights is a weak, therefore we can discard it as irrelevant. I don't know, but the language is there. And we all know that when language is there, it can be used in various ways. 2467 could almost be read as an invitation to other human rights bodies, as well as CEDAW, to include Women, Peace and Security, and for civil society organisations to raise these issues in shadow reports and to engage with the human rights bodies on these issues. Yes, human rights mechanisms are weak, we know that, but it has been argued that their greatest strength, the strength of human rights, lies in the mobilising force for constituencies for domestic reform, and maybe this could be used as such a mobilising force. And the human rights approach has been further, I think, given a boost by a framework of cooperation agreement that has been concluded between the CEDAW committee and the Special Rapporteur on conflict-related sexual violence. The latter is a Security Council mandated body. CEDAW committee, of course, is a human rights body based in Geneva. It is the first time that there ever has been such an agreement between New York and Geneva in this way. And it may be that this could help break down the compartmentalization and silos, which are very often obstacles to inclusion across different agendas, and may even help to bring the CEDAW committee's more feminist human rights slant into women, peace and security. It might help the fact that the current Special Rapporteur on sexual violence and armed conflict is a former member of the CEDAW committee. Personal relations may often do more than the more technical aspects. So, where are we? Was it a strategic decision to engage the world's most powerful actors for advancement of inclusion of women's experiences of conflict into decision-making? Or was this a fatal error by women activists to rely on the Security Council, but thereby making women's human rights objectives a hostage to changing geopolitical structures and issues of power? Was it absurd to think that the Security Council, a state-centric, masculinized body that considers military intervention as a norm, and with the world's leading arms producers as members of the Council, could ever, in fact, be committed to human rights or to a non-militarized peace? Can the proponents of human rights take language found in one context, in a Security Council resolution, link it back to a human rights context to reassert states' obligations? Or is the institutional and substantive divide just so great that this is absurd? Right, I hope you can tell me the answers, because I certainly don't have them. But what I would say is that what we currently have is a militarized security approach to women, peace and security that is at odds with a human security, human rights-centered approach that might have been progress, that might have caused progress for women's human rights. We have a UN compartmentalized and trapped in hierarchical power structures, and civil society that I think at the moment is divided. On the one hand, we are very concerned about what is happening. On the other hand, are reluctant to move away from the Security Council and to focus on human rights, because that might be a downgrading, a going back to Geneva rather than staying in New York. And let's add the massive cuts to funding for the human rights institutions that is currently ongoing. So the Women, Peace and Security agenda, already poorly implemented, is further weakened as a result of all of these different trends. And to many, this is exemplified in the latest resolution. I do think there is some optimism. I think there are entry points in this latest resolution which have been little noted but could be picked upon and acted upon. They need to be grasped and the pushback against women's human rights resisted. I'll finish with a quotation from the Special Rapporteur on Violence Against Women. Independent women human rights mechanisms, including CEDAW, including the Special Rapporteur, including civil society, which includes academia, of course, are part of the solution to push back the pushbacks and keep pushing back. Thank you.